everybody. Today we are going to be talking about the basics of how a criminal case proceeds. So once you've been arrested in a criminal case, you're taken to the jail. You will then have a bond that is set, unless your case is like a very serious case, capital murder, or you've got prior prison sentences. But most, 99% of everybody's going to get a bond. And then the bond is paid either in a cash bond to the jail or by going through a bail bondsman, which is called a surety bond. You would pay like 10% of the total amount of the bond. So if you had $1,000 bond, you might pay $100 to a bail bondsman, and then they will put up the rest of the money, or risk they'll basically sign a paper that risks the rest of the money if you don't show up to court. Okay. You have your first court date. And there are certain rules in Texas that say the prosecutors have to give the defense the evidence in the case. Now, if you have a lawyer, the prosecutors or the district attorney's office will give your lawyer a copy of all of that evidence. But there's a law called 3914 that both says they have to give it to your defense attorney, but that they cannot give you a copy. So if you have a criminal case filed against you, the DA has to give your lawyer the evidence, but your lawyer cannot provide you a copy of the evidence. We can go over it. A lot of times what we'll do is we will go over and schedule a meeting with our client to either watch the videos together or review offense reports, photos, things like that. And we can show the client the evidence, but we just cannot give a copy of it. And this was originally bartered sort of as a safety measure, that if you just hand over, for example, if you have a stranger case of aggravated assault on the highway and somebody pulls a gun on another person, but they don't even know who that person is or where they live, if you just hand over their address and everything like that, it could cause a safety issue for the victim. That rarely happens, but that's the theory behind not giving the defendant themselves a copy of these things. They have rules that say, if we're going to provide the evidence to the defendant or show the evidence to the defendant, we can't, leave it with an unredacted copy of the victim's address and things like that. So we take measures to avoid that. But so that process, all that happens. We haven't even gotten into court yet. And we're talking about so many different things there, from arrest and bail to production of evidence by the district attorney's office. So what really happens when you go to court? If you go with a lawyer, what happens is you'll just kind of wait in the audience. Your very first court date is called an arraignment. And at the arraignment, the law says they're supposed to get a plea. Either you plead not guilty and fight the case, or guilty and, you work out some type of a plea deal. But that's not really what happens. What really happens is you just go to court and the court says, I see he didn't fail to appear in court. He's coming to all his court dates. If you can work out an agreement with the prosecutor that works for your case, we call it a plea bargain, then you'll enter into the plea bargain. Maybe it is for a fine only, or probation, or even a jail sentence. But if you've reached an agreement on the first day, there probably hasn't been a whole lot of work done on the case, or the agreement is so good that we're not going to waste time by trying to find some other avenue to get a more complete dismissal. I'll give you a good example. Let's say you have a possession of marijuana case. And if you come to my office, when we have a possession of marijuana case, we're always going to try to get a couple letters of recommendation. If you don't have any criminal history, we're going to be trying to get that case dismissed. Well, there may be something, let's say the video from the officer's dash camera. Let's say you were failing to maintain a single lane, not failure to signal, not speeding, whatever, just failing to maintain that lane. And there were no other cars on the road. Well, there's a case that says your traffic stop is probably illegal. If there's no other cars on the road, you didn't do anything that was dangerous, and you're just kind of not staying within the lane marker entirely, well, then that's not a valid traffic stop. The whole case should be dismissed. You shouldn't have to do anything at all. But if we go to court on the very first court setting and we show them, you have no criminal history, you're a person of good character, maybe the marijuana that they found in the car wasn't really yours, it was in a backpack in the back. The prosecutor says to us, well, it may be true that your person is innocent, totally innocent, and I should just dismiss this case. But if they will do, this amount of community service, if they will take this drug awareness class or whatever it is, then do that, come back, and I'll dismiss the case. And I won't even check into whether or not I think I can prove the case later. Just do those things and we'll dismiss the case. That kind of thing happens frequently, and it goes faster. It's way faster to handle it like that than it would be to demand a jury trial the first day, tell the prosecutor he doesn't know what he's talking about, read the law. That kind of an aggressive approach has its place, but if you can handle the case in an amicable way, it's going to go faster and lead to an expunction, which is the clearing of all of the records of a criminal case. So that's ultimately the goal. If my son or daughter was charged with a crime, the number one goal is just to get to an expunction point as quickly as we possibly can. The expunction is what actually removes those government records. Once an expunction is granted by a court, then all record of the case has to be, erased, and you can basically say that it didn't happen. It'll look like it didn't happen. And so the faster you can do that, then the faster all the government entities will erase those records. There's certain timelines, unless the district attorney's office waives the period of time for an expunction, that can go for, up 6 months for a Class C, 2 years or a year for a misdemeanor, 3 years depending on the misdemeanor. If it's an assault family member, and they filed an information, which is a charging document, you might have to wait up to 3 years. But those are the basics. So if you have an arrest, like a misdemeanor arrest, you're trying to get it off your record, you got to get a bond, you got to get a lawyer, you got to go to court, and then you're going to negotiate an agreement. Notice we haven't talked about a jury trial, questioning witnesses, picking the jury. Those are things, we hone and refine our skill as an attorney so that we can be excellent at those things, so that during that negotiation process, when the other side is talking to us, that other side, the prosecutor is always thinking, well, what is going to happen if I go to a trial against this attorney or this defendant in this case? It's not that prosecutors aren't scared of certain attorneys, but they know some attorneys are competent in trial. And if this is a hard case for me to win, I probably won't win it, against this attorney. Or they'll know, well, this attorney never goes to trial. They don't want to go to trial. They're afraid to go to trial. So, I'll just hold out on this offer until they fold. So you have to have an attorney that is prepared and willing to go to trial, but also one that can use the ability to go to trial as a tool to help you negotiate a good agreement in your case. I hope that was helpful in explaining the process of being arrested and going through a criminal case. We did that, 8 minutes or so? That's pretty good. If you have any questions, leave them in a comment below. As always, these are for educational purposes only. We'll see you next time. Thanks so much.